Good evening, everyone. And once you have Mr. PS Rajagopal, as we all say that he's Raja of all times, especially if you have to understand the service law. After a long time, we have back with the part 8 of understanding service law and interpretation of enabling provisions. I can definitely say that if you want to understand service law, that can only be enabled through Mr. PS Rajagopal. That is his facet. And despite there being holidays in the Bangalore, he has acceded to our request that despite his hectic schedule, he will enrich us on this aspect. Over to you, and thank you, sir.
Thank you, Vikas. Why this title was chosen for today's discussion is, I felt that there is some urgency in properly understanding what is an enabling provision, what is mandatory, what is directory, and under what type, under the discretionary provisions too, when would a citizen get a right to enforce it? This is because of late, particularly after the constitutional amendment providing for reservation in favor of economically weaker sections. A trend I am seeing in the writ petitions being filed, not only in Karnataka, but elsewhere also, is that initially the writ petitions were of the nature of seeking a mandamus to implement a reservation in favor of economically weaker sections. Then in the matter of even existing reservations, I am seeing a trend these days saying that reservation is contesting that reservation provided is inadequate, or the reservation should be provided to these particular groups of castes or classes also. Let me tell this prompted me to think where we are heading. I am not saying about the desirability of the reservation, but having regard to the Constitution, the language adopted with the Constitution. In article, let me confine to Article 16 so that we can understand the things better. Now, under Article 16, Clause 1, it is a fundamental right to equality in the matter of public employment. It reads that there shall be equality of opportunity. It reads, that is, it is titled Equality of Opportunity in Matter of Public Employment, and commands. Please see the language that is used. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It is a command. Then if you come to Clause 4, nothing is this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented. Similarly, 4A, nothing in this article shall prevent the state from making any provision for reservation in matter of promotion. Then 4B, nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year. Then Clause 5, nothing in this article shall affect the operation of any law which provides that incumbent of an office in connection with the affairs of any religious or denominational institutions or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denominator. Nothing in this article, that is clause 6, shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections. If we read Article 16 as a whole, starting from clause 1 to clause 6, it cannot be, one thing that cannot be missed is that Article 16(1) assures equality, and 16(4)(3) onwards for that matter, it only enables the state and protects the state from its action being questioned as unconstitutional if it provides if it makes the reservation or in promotion or in direct recruitment or grant seniority, maybe in respect of SC, ST, OBC or economically weaker sections. These clauses provide, speaking of reservation or enabling reservation, are only to save the state action from the rigor of Article 16(1), and it is not intended to give any right to any citizen to demand reservation. Now, these enabling provisions normally start or uses the phrase like, for example, the usual language that is deployed to indicate that it is an enabling provision is the state may, for example, in there are certain there is a in any rule of compulsory retirement, or we have this rule, fundamental rule 56J, which deals with compulsory retirement in public interest. There, the word used is the government may compulsory retire in public interest a government service servant who has completed 30 years of service or 50 years of age. There it is not a penal provision. May is used to grant discretion in favor of the employer without a corresponding right in the employee. There may be cases which say it shall be lawful for the government, it shall be lawful for the state. As for example, in recently in some provisions, for example, when they in Bombay State issued an ordinance where it said that the provincial government may, with a view to carrying out the purposes of this ordinance, by order require any person to furnish such authority as may be specified in the order such information in his possession relating to any land which is requisitioned or is continued under requisition. Every person required to furnish such information as is referred. Then in Land Acquisition Act, you will find that for the purposes of acquisition after issuing preliminary notification, it shall be open to the officer authorized by the government to enter the land, take measurements, and to determine whether the land is suitable for the purpose for which it is sought to be acquired. Like that, there are any number of enabling provisions which enables the government or the authority specified to do certain things without any corresponding right in the citizen to demand such action or to feel aggrieved by such action. Now, compulsory retirement in public interest, it has been held in any number of cases that it is not a penalty because it is not stigmatic. Secondly, there is no loss of retirement benefits. Thirdly, it has been held that it is intended to effectuate public interest and not defeat any right of the employee. That is, where a discretion is vested in the state, without affecting any right of any third party, then those provisions are enabling and would not create any right in the person who is affected by exercise of such discretion. But there is one caveat, because that is Article 14. That is, if the power to compulsory retire is exercised arbitrarily, or if it is exercised discriminatorily, or if it is used to wreak vengeance, then the action of the employer becomes justiciable, not because no notice is given to the employee, or not because the power is not there in the employer to compulsory retire, but the concept of equality includes the concept of equality in Article 14 includes right to be treated fairly and non-discriminatorily, and use of power for the purpose for which it is given, and not for extraneous purpose to victimize an employee. There are at the same time, there are many rules where it is held that if a rule is made to effectuate a third party right, then the rule will be mandatory. May will have to be read as shall. Two examples in service jurisprudence that I can quote immediately is, there is a one rule which said that is reference of the disciplinary inquiries of government servants to the tribunal. That is where is that rule said that discretion is to be yes. In state of Uttar Pradesh versus Joginder Singh, this rule came up for consideration before the Supreme Court. There the rule 4, it reads like this: Governor may refer to the tribunal cases relating to an individual government servant or class of government servants or government servants in a particular area only in respect of matters involving corruption, failure to discharge duties properly, irremediable general inefficiency in a public servant of more than 10 years standing, and personal immorality. The stand of the employer was that when I want to refer that is the state government stand was, if I want to refer the case to the tribunal, I can refer the case to the tribunal. If I do not want to refer the case to the tribunal, I can have an inquiry conducted by my officer and take appropriate necessary action against the employee. Then the Supreme Court said, Rule 4.2 deals with a class of government servants who are generally called as gazetted servants. No doubt there is a discretion, but the plain and unambiguous object of enabling Rule 4.2 is to provide an officer to the gazetted government servants to request the governor that their cases should be tried by a tribunal and not an officer of the government. The rulemaking authority presumably thought that having regard to the status of the government servants, it would be legitimate to give such an option to them. Therefore, we feel no difficulty in accepting the view that Rule 4.2 imposes an obligation, that is, A discretion coupled with an obligation makes the rule mandatory, even though the word may is used. Therefore, we feel no difficulty in accepting the view taken by the High Court that Rule 4.2 imposes an obligation on the governor to grant a request made by the government servant that his case should be referred to the tribunal under the rules. Such a request was admittedly made by the respondent and has not been granted. Where a discretion is vested in an authority to effectuate a right of the third party, then that third party can insist that the rule has to be treated as mandatory. Of course, there are rules which say, for example, the rule in disciplinary proceedings. This is a common area where most of us will be concerned. There is a provision for the defense assistance being rendered to an employee facing disciplinary. Normally, the phraseology of rule be somewhat like this. The employee facing disciplinary inquiry may take the assistance of a co-employee, but he shall not be defended by an advocate except where the presenting officer is a legal practitioner or the disciplinary authority having regard to the facts and circumstances of the case permits him to do so. Or it will be like this. Disciplinary authority may permit an employee to be defended by an advocate having regard to the facts and circumstances of the case. Now, if you take this rule, there are three important phrases. One is shall. That shall will operate when the presenting officer appointed by the disciplinary authority to present its case before the inquiry officer is a legally trained legal practitioner, or to borrow the phrase used by the Supreme Court in J.K. Agarwal, or a legally trained mind. A person may not be wearing the badge of an advocate, or he might have not have received sanad from Bar Council. Even if he is not a legal practitioner, if he is a legally trained mind, that is where Supreme Court looked to the substance than the label. There it is mandatory. Undoubtedly, the phrase uses where the disciplinary authority, where the presenting officer appointed by the disciplinary authority is a legal practitioner. The word used is shall. Second clause, it requires focus on two phrases. One is disciplinary authority having regard to the facts and circumstances of the case. That is, having regard to. Two is may permit. Now, this is definitely a permissive. That is, it grants discretion to the authority to grant or not to grant. But that discretion is conditioned by one important phrase, that is having regard to facts and circumstances. What is having regard to? There are divergences as to, in a particular case, whether an employee is entitled to be defended by an advocate. My experience is that the judgment will depend upon the personal view of the judge in most of the cases, barring a few category of cases where it is easy to make up one's mind that having regard to the facts and circumstances of this case, whether it is fair and just to provide a. Now, having regard to means, in exercising the discretion, the competent authority will have to keep in mind or apply his mind to the circumstances of the case. Now, what are the circumstances of the cases? Circumstances of the case may be that it involves interpretation of complicated questions of law. At one point of time, it was thought that interpretation of personal law is a complicated question of fact, a complicated question. Then there may be cases where the employee is facing on the same set of facts a criminal case as also a disciplinary inquiry. There, the defense will require adducing of huge evidence with emphasis on interpretation of that evidence. That is another aspect to be borne in mind. That is, having regard to means having having regard to is a command to the authority in whom the discretion is vested to consider the facts which are required to be taken into account. Having regard to, for example, in Old Motor Vehicles Act, 1939 Act, permits were limited. Applicants were large. Then what was the command to the regional transport authority or state transport authority? The authority will decide the applications having regard to public convenience, capacity of the applicant to provide efficient transport system. Third, the financial capacity of the applicant to provide replacement for the bus, to provide adequate staff. Therefore, regard to the financial capacity, regard to public convenience, various factors are laid down, and all the factors following the phrase having regard to will have to be borne in mind. There, a discretion is vested subject to two conditions. One is having regard to the factors mentioned in the rule. Second is the consequences of the inquiry on the employee. Though the rule which says unless the disciplinary authority having regard to the facts and circumstances of the case so permits, it gives an enforceable right not to make the disciplinary authority exercise his discretion in a particular manner or to arrive at a particular decision. But it gives a right in the employee to enforce the exercise of discretion, sometimes, though not, maybe in the exact manner he wants it. This is a case of discretion vested in an authority coupled with certain conditions. There, if the conditions are satisfied, a writ would be issued to exercise discretion in favor of the employee. But discretion nonetheless exists in the employer, and the rule cannot be said to be mandatory. At the same time, there are certain rules. Say, as for example, a rule which came up for consideration before the Supreme Court in Wasim Beg. In Wasim Beg, there was a in Wasim Beg, there was a rule which no. Wasim Bey. This was a rule dealing with the discharge of a confirmed employee. Page 20. Wasim Beg was a case which was concerning a service rule in UP State Leather Development and Marketing Corporation. There was a provision in the rule which said a confirmed employee may be discharged from the services of the corporation under the orders of the competent authority on 3 months' notice or by giving 3 months' salary in lieu thereof. The competent authority for purposes of this rule will be next higher level than the appointing authority for that category of post. The competent authority getting a recommendation from the appointing authority for discharge of a confirmed employee with reasons therefore may give an opportunity to the employee concerned for explaining himself before coming to a decision. Now there are two parts of this rule. One is the recommendation made by the appointing authority. Second is decision to be taken by the competent authority. And this is coupled with the clause, the competent authority may give an opportunity to the employee concerned for explaining himself in before coming to a decision. That is, word may in the normal circumstances would indicate that the competent authority may give notice or may not give notice. The court held that since it involves following of natural justice or compliance with natural justice, the rules shall be held to be mandatory, even though the word used is may. Or to put it differently, where a rule is intended to, or where a provision of law is intended to act or to effectuate fairness in administration, that is, compliance with natural justice, word may to plainly confers a discretion. It has been held to be not discretionary, but mandatory. That is, giving of a notice of the report of the appointing authority, which contains reasons why the appointing authority is recommending to the competent authority to discharge this confirmed employee. The reasons and the recommendation both will have to be put to the concerned employee so that he has a right to represent and persuade the competent authority that the report of the appointing authority recommending my discharge is factually incorrect and legally untenable. This also flows from the fact that loss of employment would result in loss of livelihood of the employee. And the provision of issuing a notice is intended to effectuate the right of the employee to protect his life or by protecting his livelihood. Therefore, where a provision is intended to effectuate natural justice, the word may is not decisive, and though it is discretionary, in the matter of issuing notice, there is no discretion. The may will have to be read as shall. In the matter of appointments, those of us who are practicing this law, we always say that by inclusion of a person's name in the select list, no right accrues to him. It does not give him an indefeasible right to be given employment. And when it comes to inclusion of a name in the reserve list, or what is normally called as, sometimes referred to as the additional list, unless the rule itself says that reserve list shall be operated for such and such a purpose, there is no right in an employee to insist on operation of the reserve list. Or to put it differently, the rule is that generally, presumption, general view in law is that the person in the reserve list has no right to be employed, because person in the main list itself is not having any right to be employed. Here again, whether the discretion to operate the additional list or reserve list is mandatory or only directory, that would again depend on the purpose of the rule, and by reading text of the rule, whether it is possible for us to discern that there is any duty vested or duty obliged to be performed by the authority. Because one principle is that discretion coupled with duty is mandatory. It will have to be exercised. Now, in the matter of appointments to the post of member sales tax appellate tribunal, the Delhi Sales Tax Act, it provided that any vacancy in the membership of the appellate tribunal shall be filled up by the central government as soon as practicable. Kindly see the phrase, shall be filled up by the central government as soon as practicable. Therefore, there is a duty in the government to fill up the post of member sales tax appellate tribunal as long as practical. Then to effectuate this, a official memorandum had been issued by the government in consultation with the Public Service Commission. It said it has been decided that reserve lists may be operated in cases where a vacancy is created by a candidate resigning the post, or in the event of his death within a period of 6 months from the date of his joining the post, subject to the condition that such operation of the list should be limited in respect of statutory posts and those of scientific, technical, academic, or medical nature or other similar nature, and it may not be possible to keep the post vacant till the completion of fresh recruitment or to make local arrangements. The word used is may. What it says is, reserve list may be operated where the person who joins leaves the office within 6 months. The question came up whether person who is placed number 1 in the reserve list, whether he has a right to insist that he should be appointed the moment a person who is appointed from the main list leaves the service within 6 months. Supreme Court answered it, saying that this is a case of conferment of power together with a discretion which goes with it to enable proper exercise of the power, and therefore it is coupled with a duty to shun arbitrariness in its exercise and promote the object for which the power is conferred, which is undoubtedly in public interest and not individual private gain. Then, holding so, it said that it is settled that every state action in order to survive must not be susceptible to the vice of arbitrariness, which is the crux of Article 14. When a policy has been declared by the state as to the manner of filling up the post and that policy is declared in terms of rules and instructions issued to the PSC from time to time. And so long as these instructions are not contrary to the rules, the respondents ought to follow the same. That is, operation of reserve list in the circumstances mentioned in the OM were held to be mandatory. Though the word used is may, and general law is that no person in the reserve list has got any right. Then there is another category of case. For example, in where even if there is a discretion, the courts have held that even if a mandatory language is used, even then it is discretionary. For example, in we come across in the courts, but luckily for us, these days it is reducing, except by big manufacturers of liquor. Now, what is this meaning of the word discretionary power? Discretionary power implies freedom of choice. A competent authority may decide whether to act or not to act. Now, for example, particularly in liquor policy, the constitutional policy has been that liquor trade and liquor manufacture is a monopoly of the state, and license to trade in liquor is only a privilege. Therefore, it has been held in any number of cases that grant of license to manufacture or trade in liquor is purely discretionary. There is no question of any mandatory provision for grant of license. The provision in law contained, Commissioner may, with the approval of the government, if he is satisfied after making such inquiries as he may consider necessary, issue the license, may issue the license. Commissioner may, if he is satisfied with the previous permission of the state government, may issue the license. This is the substance of the rule. Then interpreting this rule, the Supreme Court gave two important dicta. One is, the rule is undoubtedly discretionary, and constitutionally, there is no right in anybody to insist on getting a license to manufacture or trade in liquor. Therefore, the policy of the law that manufacture and trading in liquor is a monopoly of the state, and what is given to anybody by way of a license is only a privilege to vend or privilege to manufacture. Therefore, absolutely the rule is discretionary, and there is no compulsion even to exercise that discretion. Because when I say a rule is discretionary, in its enforceability, there are two things. One is whether discretion can be insisted to be exercised, either in my favor or against it. That is different. Second is discretion, whether it confers an obligation to act in my favor only. The discretion is, that is where may will become shall. Supreme Court said, in the matter of liquor trade, having regard to the plain language of Rule 4 and Rule 14 in that case, which use the word may at more than one place, and having regard to the policy of the liquor policy adopted by the state, there is no mandate to say that discretion shall be exercised at all. That is, the authority can even not refuse to take a decision on the representation or on the application. But another important aspect was that was stated with Supreme Court was that the discretion either to act or not to act or to act in a particular manner has to be exercised non-arbitrarily. That is, whether the state can say that, yes, Mr. A, I will not grant license, I will not even consider his application. Mr. B, I will consider his case and I will grant him license. Supreme Court said no, because importance of non-arbitrariness is an element of and cornerstone of Article 14. It said, no one can claim as against the state the right to carry on trade or business in liquor, and the state cannot be compelled to part with its exclusive right or privilege of manufacturing and selling liquor. But when the state decides to grant such a right or privilege to others, the state cannot escape the rigor of Article 14. It cannot act arbitrarily or at its sweet will. Therefore, even where a power is held to be purely discretionary, in exercise of discretion, there will have to be reasonableness, and every beat of state's action should pass through the golden thread of non-arbitrariness. Then there is any number of cases where the word shall has been interpreted as may. The law is that, suppose, it shall be granted if it is used. For example, in the rules made under Representation of People's Act, there is a provision. A ballot paper contained in a ballot box shall be rejected if it bears any serial number or mark different from the serial number or marks of ballot papers authorized for use at the police station or the polling booth at which the ballot box in which it was found was used. Supreme Court rejected the argument that because the word shall has been used, it gives a mandatory direction to reject the ballot paper. But it granted the relief on another ground. That is, there were 4 clauses in Rule 47 which dealt with different situations as to when a ballot shall be rejected. Though the word used in all these 4 clauses was the word shall, Supreme Court did not buy the argument that because it is shall, it is discreet, it is mandated. But the Supreme Court examined what will happen if the word shall is not read as mandated. Can you reject a ballot paper 50% and 50% of the ballot paper can you accept? No. A ballot paper casting a vote, either it has to be rejected or it has to be accepted. There is no midway. It is not said because this discussion allows. Because the difference between a mandatory provision and a directory provision. A mandatory provision must be adhered to 100%. Whereas directory provision, if there is substantial compliance, it is enough. The question posed to itself by the Supreme Court was that, is it possible to say that test of substantial compliance can be applied to a rejection of a ballot paper? It has to be either rejected or accepted. There cannot be a degree of compliance. Compliance should be full or you don't reject it at all. And if it is not rejected, even substantial compliance cannot be ensured. Therefore, the word shall will have to be read as shall only. Therefore, whether a provision, a discretionary provision, is mandatory or directory, or whether it gives an enforceable right, it would all depend upon the purpose for which the power is conferred, or the purpose for which the discretion is conferred, then whether it is conferred to effectuate a third party right. What is the scheme of the entire law? Say, for example, if we are interpreting a particular provision in disciplinary proceeding, disciplinary rules, what is the scheme of the entire disciplinary rules? And then you see whether what will be the consequence of not granting or granting a permission. Then third is the purpose for which the power is conferred. Then whether in exercise of the power, whether there is a corresponding duty. Now it's, say, for example, one of the aspects, that is now, for example, there is a discretion vested in an authority to correct a wrong. That is Section 35 of the Income Tax Act. Now it reads, that is, it would say that the income tax officer may rectify any mistake apparent from the record. That is, an assessment order is passed, then the assessee makes a representation saying that, look, there is an error apparent on the face of the record. Therefore, correct it. The word used is may correct. But what is the purpose of the discretion vested in the ITO? In the ITO, the discretion is vested to render justice to the assessee. The principle that is enunciated is that where a discretionary power is vested in an authority, and that power is granted or conferred on him to effectuate a right of a citizen, then it is mandatory. Now, in service jurisprudence, we find the clauses, discretionary clauses, both in rule regarding voluntary retirement and rule regarding resignation. What it normally says is, of course, different types of rules are there. There are 3 or 4 types of rules. The rule which does not require acceptance, the rule which requires acceptance, then the rule which says that under these circumstances it will not be accepted. I am not on those aspects. I am on the aspect of notice, period of notice required. Now, in most of the service rules, the provision is the employee shall give a notice of 3 months. That is normal rule. But there is a provision also provided the competent authority may waive or reduce the notice period. That discretion is there. Now that discretion can be refused to be accepted because it is a discretion. But still, why that provision for reduction or waiver of notice period is made? It is made to effectuate the right of the employee granted to him under Article 19(1)(g) of the Constitution of India. That is, the employee has, every citizen has a right to pursue the avocation or profession of his choice. Therefore, the requirement of reducing the notice period is in the aid of fundamental right of the citizen under Article 19(1)(g). Then another the constitutional prohibition, that is rule against beggar, because Article 23 Article 23, prohibition of traffic in human beings and forced labor. Traffic in human beings and beggar and other similar forms of forced labor are prohibited. To put it in simple terms, an employee cannot be forced to work under an employer if the employee is not willing to work under. Therefore, the provision in the rule empowering or enabling the employer to reduce or waive the notice period serves a public purpose of effectuating fundamental right under Article 19(1)(g) and aids implementation of prohibition under, or the aids protection against the prohibition under Article 23. Therefore, though the word may is read as may only also without reading it as shall, the discretion to waive or reduce the notice period cannot be denied arbitrarily or without due application of mind. This is a provision which, though not mandatory, cannot be ignored to be exercised lightly or for no reason. Now suppose, and then of course, it cannot be denied arbitrarily. Out of 10 employees who have resigned, in case of 9, you reduce the notice period, and in case of 1, you say that it has to be fulfilled to the letter and to the letter of the law. It would look unreasonable. Of course, if there are reasonable, if there are valid reasons, say there is a work this employee is doing which he cannot leave midway, and to make alternate arrangements, we require 3 months, then non-waiver or non-reduction of notice period may be justified. In other cases, where there is no such exigency and no harm would be caused to the employer by waiving or reducing the notice period, though the word used is may, the court could insist in the facts and circumstances of a particular case to hold that it is mandatorily, the discretion will have to be mandatorily exercised, maybe in a given case in favor of the employee. In other case, they will have it is an enforceable discretion, and sometimes in a particular manner also. Therefore, all that I can say is that the interpretation of a clause or a rule or of a law which apparently vests a discretion in the authorities would not depend upon the use of the word in the rule as may, or it shall be lawful, or it shall be permissible, or the like, or the use of the mandatory word shall, which is definite direction. It depends upon the scheme of the enactment. It depends upon the fact whether the rule is made for the benefit of the government or the employer, or for the benefit of the employee, or in public interest. It would depend upon the context of the power. It would depend upon the breach of or effect on the constitutional rights of the citizen if a particular interpretation is given. It would also depend upon the general practice or the generality of application of the rule to the fact situation, as if in vast majority of the cases it has been definitely given reading may as shall, then the non-arbitrariness also will play a part in the interpretation of the rule. And interpretation of discretionary and mandatory provisions, what is enabling, what is discretionary, what is mandatory. It is a very theoretically, it is a very complicated issue. But in practice, if we apply our mind to three things as to why this provision has been made, what is the consequence of not granting that it is the discretion has to be compulsorily exercised, and what would be the effect if on the enterprise and also on the employee if it is interpreted in a particular manner, and more importantly, and this is most important, whether treating the provision as mandatory or direct will impact the constitutional principles of equality, non-arbitrariness, then right to life and liberty, and fundamental rights under Article 19(1) of the Constitution. These are the broad guidelines. Then, depending upon the purpose for which the power is conferred, it will also throw light on what is mandatory and what is not mandatory, what is enforceable and not what is not enforceable. This is why I am speaking on this today is that I found that number of good cases are lost by default because we are misled into believing the language of the rule decides the fate. Even where the word used is may and it may appear ex facie discretionary. We have to research into all the various aspects, as I was telling, to somehow see whether it can be interpreted to be mandatory to give relief to a citizen. I'm not talking only of the employees. Whether it can be used for societal good by making it possible to be interpreted as mandatory, because unguided discretion is at the root of all evils in administrative law. Unguided discretion is what is anathema to a democratic polity like ours. Thank you very much. If it has been a hard subject, please excuse me, because the interpretation of law is always hard. But once you understand the basics of why the law is like that, then the solutions will be easy. That is why my law teacher used to tell, If you know what is the law, you are 100% right. If you know why the law is like that, you will be 150% right.
They also said that probably I can say that where there is a law, there is a flaw. And where there is a flaw, there is a lawyer. And that has to be Mr. PS Rajagopal.
Not necessarily.
No, I'm taking cue from what your teacher said to you. What according to you, like in reservation, we say that we have read in a lot of judgments that it was an enabling provision under Article 16 or in some other articles also. What is your take on that? How do you interpret for those articles that it is an enabling provision for the purposes of reservation? And what is the mandate?
The answer is provided by the Supreme Court in Ajit Singh 2. The first question that was answered was whether right to be considered for promotion is a statutory right or a constitutional right. Now it extracted all the clauses of Article 16 and said Article 14 and Article 16(1) are closely connected. They deal with individual rights of the person. Article 14 demands that the state shall not deny to any person equality before the law and equal protection of laws. Article 16(1) issues a positive command that there shall be equality of opportunity for all citizens in matters relating to employment to any office or under the state. Right to be considered is not a mere statutory right, and there it distinguished the judgments in Ashok Kumar Gupta and Jagdish Lal, which said that it is only a statutory right. And then said, when we next come to the question whether Article 16(4), 16(4)(a) guaranteed any fundamental right to reservation, it should be noted that both these articles open with a non-obstant clause. Nothing in this article shall prevent the state from making any provision for reservation. There is a marked difference of the language employed in 16(1) on the one hand and 16(4) and 16(4)(a) on the other. There is no directive or command in Article 16(4) or 16(4)(a) as in Article 16(1). On the face of it, the above language in each of the articles is in the nature of an enabling provision, and it has to be so held. It has been held so in judgments rendered by constitution benches and in other cases right from 1963, because it said a balance has to be struck between command in Article 16(1) and enablement in Article 16(4) onwards. Therefore, this is only an enablement, and basic thing being positive direction in Article 16. And the language, suppose the 16(4) had said there shall be a reservation in favor of backward or whatever classes, then it would have been mandatory. In the scheme of the language used and having regard to the positive mandate of 14 and 16(1), reservation provision has been held to be an enabling provision. However noble it may be, however desirable it may be, but as the law stands today, it is only an enabling provision. And you will be seeing whenever we go on street, a reservation is our birthright. Such type of slogans we see on the walls. This is this is encouraged. I don't know for what purpose, but we should know that under our constitution, reservation is only a enablement. It is an enabling provision.
So one person has asked sir to explain enabling provision in a very simple language, which a common man can understand rather than taking construction from the law.
Enabling provision is, now this arose under Companies Act. Whether commission can be paid from out of the profits to the foreign selling agent. Originally, there was no provision in the Companies Act to do it. Then a provision was introduced. It shall be lawful to pay commission. Till that amendment came, it was not lawful to pay the commission. Now, by using the phrase, it shall be lawful to do a thing, what the legislature is telling? Don't have fear that it shall be lawful. It will be unlawful. You are under no compulsion to give. But if you give, it will not be unlawful. That is an enabling provision which enables the company to pay commission to the persons who mobilize investment into the company under that particular act. Then, for example, there is another, as I was telling, the another case of enabling provision, that is now, for example, take the Stamp Act. There is a provision in every state act, Stamp Act, that the chief controlling revenue authority of that particular state may make a reference to the High Court if in his view it requires such a reference. Whether it is a mortgage conveyance defined in the Transfer of Property Act, it is complicated question to be decided by a judicial. He may draw up a statement and refer the case to the Supreme Court, to the court, where such a provision is there. Plain language is, it is discretionary. But take a case where there is no decided judicial view on interpretation of a particular type of document or a particular language deployed in the document. Then the rule, though discretionary in normal circumstances, in the circumstance of that document, it becomes mandatory. In law, there are no legal, there are no laws. If suppose they say, in every case, the revenue authority shall refer the matter to the High Court, then the revenue authority becomes a post office referring every matter to the High Court. At the same time, if there is no empowerment in him to refer any case to the High Court, then it will result in public injury. Therefore, a balance will have to be maintained between a rigid rule and public injury. It is, if a law says either this, that is either full or either nil, then society is likely to end up in the position of nil. Therefore, the discretion is a necessary element of public administration. We cannot say that every provision should be mandatory only. 2 into 2 can be 4 only. Yes, arithmetic. But life is, managing the society is not arithmetic. Therefore, the exercise of discretion and certain amount of free play is necessary in administrative law. Therefore, I cannot straight away answer simply what is meant by empowerment and what is meant by enablement, what is meant by mandate. That is the reason multiple tests have been laid down by the courts. When you treat something as mandatory, when you treat something as only an enabling power, and when you say that, when do you say that whatever it be, citizen has no power to insist on discretion being exercised, as I was telling, as in the liquor trade. Therefore, I cannot give a ready-made lollipop as a solution. And the interpretation of law, particularly whether something is discretionary or mandatory, it has to be on multiple factors.
So the last question would be like if we use in Nagraj also, M. Nagraj and all, they said that the reservation, etc., was on the basis of enabling provision, etc. So how will you explain that?
That is, if the state makes reservation, providing reservation itself will not be unlawful. That is why that is the starting words of 16.4. Nothing in this article shall prevent the state from making reservation. Then 4A, nothing in this article shall prevent making reservation in promotion. 4B, nothing in this article shall prevent the state from granting seniority with promotion. Therefore, if the state grants reservation in promotion, or if the state grants consequential seniority along with promotion, that by itself would not be unconstitutional. Then, of course, any reservation and any consequential seniority given may also not be lawful, because there are other aspects like efficiency of administration, adequacy of representation, then so the competing interests, and for how long this can be, because in one judgment I also find there is an element of time factor also in the matter of reservation. Of course, Supreme Court has not got too much on that extent. All that in Supreme Court, in M. Nagraj also, what the Supreme Court said? Supreme Court said, did not pronounce that individual enactments made by each of the states providing for consequential seniority is lawful. No, it did not say that. It said 16.4A, 16.4B, they are constitutionally valid. In the sense, you cannot say that it offends the basic structure or it is unlawful by itself. And then it said, after declaring that constitutional provisions are valid, it said, validity of each state enactment shall be decided by the benches to which they are assigned. Each of these cases are assigned. Nagraj only said 16.4A and 16.4B are valid. That is, insofar as they enable the state. Whether that enablement has been properly exercised by the individual states is a matter that was not decided anymore.
So the next question of fallout is, EWS would also come within the trappings of enabling provision. What do you say about the latest judgment on that?
What is that? Sorry,
the EWS reservation, it comes with the enabling provision, or how does it come?
It is also an enabling provision also, because 16.6 also reads only nothing in this article shall prevent. That's all in fact, 16.6 says, nothing in this article shall prevent the state from making any provision for the reservation of appointment or post in favor of any economically weaker sections of citizens other than the classes mentioned in clause 4. It is also an enabling provision. All these provisions for reservation are enabling only because they are worded so. And the manner in which these clauses providing for reservation will have to be distinguished is 16.1 is law of mandatory application. that is equality in the matter of public employment. 16(4) and onwards, they are matters which enable, without disturbing the broad concept of equality in 16(1) and having due regard to the efficiency in public administration. Of course, what is adequate representation? Then how the efficiency has to be mentioned. This Pavitra said something that Pavitra has subsequently been deferred by 3-judge bench in Jarnail Singh. And after Jarnail Singh, though in Jarnail Singh it was said that creamy layer can be applied even in respect of SC/ST when it comes to reservation and promotion. No state has come forward to apply that creamy layer. That is because, yes, it is easy to leave these matters to the judiciary to decide. That is what the legislators and the executive think. And unfortunately, somewhere, this judiciary also started appealing to public popularity rather than sitting down and seriously interpreting this. This I am saying.
One of the senior counsel in his office out here has written the law is what the judge decides on that particular day and moment. One last question is, one has said, can VRS be accepted within the 1 week?
Can be. It can be accepted even within a day. If because right power to waive the notice is there in the employer. But the circumstances of the case must justify it being accepted. Say, take for example, if you are if an employee working in an organization applies for any other employment, he has to do so through the employer. Most of the organizations require it. And then he is in public sector employment. He gets a job in Government of India, for which he has applied through the employer, and time to join that service has been given very inadequately or very short time is available. Then it may not be fair for the employer to insist that, look, I will not condone the notice period in your case, requirement of the notice period in your case. It can be accepted even within 1 day. There is no problem about it. But if you want to enforce that 1 day acceptance, you will have to have a strong case that how the employer was aware of this contingency arising, how he acquitted with all that, and finally how he has reneged from it. All these will have to be established.
Yes, sir. So thank you for sharing your knowledge, and we wish that you enjoy your holidays. And you also keep on studying so that we are also kept on being enlightened. The sun should continue to sunshine. Thank you.
Thank you.